Hello, everybody. Hello, Jerry Matthew Boyd. Hello, Buzzy Pug. Hello, Ava, making her appearance. Come on. Let's see. What do you get tonight? What do you get tonight? Well, we'll empty this bag. She's on her final duck rings. You know how she loves her duck. That's it. There's just crumbs and the anti-moisture pack. You good girl. Right there it is. Hi, tiny kitten. Hi, my baby girl. Oh, I love you too. I love you, tiny kitten. All right, set that one off to the side. As you can see, I got a few more boards on the exercise cat wheel. I'm about a quarter of the way done, is my estimation. And today the cat trees arrived. So I need to hurry up and be all the way done so that I can get the couch out of here, get that moved over to the side, and get the cat tower, cat tree, condos things set up. I'm so excited. Hello, Nana Laura. Hello, Purple Kiv. I do love you. Hello, Wire Mother. I cannot believe that I got this. All these hearings. There's 5 of them. 5. Hello, Mortimer Duke. Hello, Michelle Moreland. Hello, Joey Bag of Donuts. Guess we get to find out together what. Hold on, I'm looking. I'm scrolling back. I must be missing the comment. Oh! Ha! Follow the case. Or following the case. I put it in the description. It's in the title. And there's a playlist called FTC, Following the Case. Yeah. It's just something that I've done since I had the channel. I love collecting the dockets. I harvest them every day, and then I like to string them together so you get the full story, the whole context, because you learn just a little bit at each hearing. Sometimes it's, useless information. Other times you learn 41 charges. Okay, we can empty this bag too. Oh, dag nabbit. I spoke too soon. There's 3 of them in there. Yes, you can have them. Bethany, get in here. Put some screws in that thing. You're very, very well versed in screwing, I hear. Allegedly. Bethany's not helping me. She's not worth anything. the mess she makes. And hello, Spider-Man. Not even kidding you, the song went through my head. I don't like you. I love you. Not for another 2 weeks. He's got to stay kenneled. Once he gets fixed, and then I change out all of the litter boxes, then it'll be fine. I'm gonna have to pull Ava's kennel out and blacklight wash it for points of reference. But it'll be okay. I've got enzymatic cleaners, and I just have to tolerate smelling like a cat lady for 2 weeks. That's all. Snitch is worth it. Coming from the guy who called me while I was in the shower or texted me. I replied with a voice message, and he can't get attachments on his phone. But yeah. He texted me while I was in the shower. Goofball. What's your question, Jerry? Out of Bert and Ernie, which one had the long head? All right, hold up. In Sesame Street, was it Bert or Ernie that sang the Rubber Ducky song? Oh, it didn't. Dag nabbit. I'm using it on my computer. In Sesame Street, was it Bert or Ernie that sang the Rubber Ducky song? Ernie. Ernie sang it. Ernie. Yep. I think your YouTube's broken. You first you couldn't read or first your comments wouldn't post, and then or they'd disappear or something, and now it's scrolling oddly. It's broken. It's you. They're slower. Is it a optical illusion? Hold on. No, I don't want to ban the user. No, come on. No, hide it. Unpin it. No, do I have to go to the original one to unpin it? It's not letting me unpin from the pin. Maybe I didn't pin it the second time. I think I did. Hold on. Let me go studio. And okay. Now jump in here. Unpin. There we go. I couldn't unpin it from StreamYard. I had to go to YouTube to unpin it. The only thing I can do from StreamYard is ban myself or others. Okay. Hopefully that fixes it for you, Mortimer. Duke. Oh, yeah. Like a powdered donut. Yeah, his chair annoys the hell out of me, but I like the poster. Okay. Look at this. Oh, you remembered. That's even better than you remembering Valentine's Day. Let's see. Did I get everybody? I think Dark Zoomy! Hello. How you doing? Oh, Ava. Now you're jealous of them? Oh, well, you can have it, honey. I put it there for you. Good girl. And tons of love. And fur. Lots of fur. Huh. Well, Eileen was mentioning the other day that some of the comments that I was posting, she wasn't seeing. I know, remember the old trick where you had to go in and change it from top comments to all comments or something like that? Maybe that's the deal? I don't know. I don't know. All I do is clickety click and I'm on. Doubtful. My, Earl. What did you see, bud? What did you see, bud? Oh, this is adorable. What you going after? I don't know, but it's something. He's always been a weird one. Love him to bits. The goofball. Oh, and I love you too, Ava. You're my big girl. Yes. No one hogs a bed like Ava. Stop it. I'll send Earl to get you. Oh my gosh. Mortimer Duke. It's Sesame Street, for crying in the mud. How can you even create a thought like that? It's Sesame Street. Oh, I guess that's how. Hello, Linda Applegate. Bert had the long head, but I did look it up, and Ernie is the one that sang the song. You, what? Like, seriously, don't you ever get tired of this? Don't you ever get tired of this? Like, is there ever enough? Is there an off switch? Are you AI? Come on, let me see. Let me see. I gotta find the off button. Boop. It didn't work. Hold on. Let me. I gotta. Maybe I gotta push it twice. Boop boop. Boop. scared. I'm scared because I have text and stuff on the video, and usually when I get really crappy nights like this, where the chat is lagging or the picture's not loading well enough, then hey, you know what? I had a thought. Okay. Hopefully it's fixed. Oh. Everybody says hi. It's a blanket hello. We share an umbrella. Hey, Ava. I can hear Earl protesting. She don't want to play like that. Well, no, she does. He don't. Just a little bit. Just a little bit. I know. Ava is the brand. I'm the sidekick. So I fixed it. Yay, I fixed it. Yes, change top chat to live chat to see all the chats. I swear he does acid. I can't find his stash, but I'm sure of it. Well, exactly. I'm not allowed dogs. I'm not allowed any other dogs. Not at all. That's why I keep getting cats. Actually, the cats keep finding me. Like I did not invite Snitch in. I did not. I didn't do that. All I did was open my door. I should be able to open my door without having a herd of cats come flying in. Okay, it was only one, but it felt like a herd as I was herding it through the kitchen. Wait, you're not tiny kitten. Get back here. Who are you? Get back here. Boop. Her face was precious after I booped her nose. How is that possible? How is that even a thing? It's at the very top. It's at the top for everybody. Hold on. View channel. Click on this real quick. There. Okay. All right. So shoot, it might be different for me because I'm, kind of the person. I'm sorry. I was going to show you, but it's not going to allow me because it gives me other things like setting super chat goals and, grifting for money, which I'm not going to do. Sorry, I tried. Hello, Squishy. Yeah, he pretty much just waltzed right in too. Okay, just to the right of your 75 XP, um, oh, oh, I see. You already did that. Top messages, all messages, fan funding, and you can't, like, it doesn't scroll at all. But all messages should be live messages. That should be, so it's just worded differently because you still have top messages, but you have, oh, the fan funding thing must be just so like you would see when people super chat or purchase memberships or something and nothing else. Like that doesn't sound appealing to me. If that's the only thing you can see. But yeah, all messages should do it. That should be good. That should be the right one. Who, me? If I were any more special, my name would be Ed. Yeah, so I'm assuming one of y'all has an iPhone and one of y'all has an Android. And so it's just worded differently on the brand of phone. That's my guess. That is my guess. And my phone's locked up. Stop it! Oh, no. Yeah. Oh, my build is out of date. I guess I shook my phone a little too hard. All of a sudden, it's like, wait, we need an update. Update us. I'll just set that there. Well, that could be it too, that, a laptop versus phone. I don't know. The point is you should have 3 options, and top messages is not the one. Oh, well, that's kind of what Morty was going through. He had to close it out completely and restart it. Yeah, I'm just going with the explanation that there are 3 options and top chat is not one. The other one, whatever it is, whether it's live chat or all messages or whatever. The heck was that? Which one of you made that noise? That was weird. Y'all are weird. It sounded like it came from my computer speakers, but it didn't. But Earl was right behind me going goofy. And Ava's got to go potty. What are you looking for over there, Budsy? No, I do not have critters of any kind. They all have their flea and tick treatments. The house is regularly vacuumed. I have no bugs. So I have no idea. I have no idea what he's going bonkers about. Duly noted. Thank you for being my guinea pig. A spirit of her? Hell, she's not dead yet. She just looks and smells like it. Okay, sweetie, thank you so much. She probably did. I'll betcha. Oh, I'll betcha. She keeps falling off the wagon, and I keep bailing her out and helping her back up, and next thing you know, she's passed out on the floor again. Wiggle it just a little bit. Oh, all right, guys. I need to let Ava out, so I'm gonna put the Ricky on. The Ricky. Hold on. The Ricky. He now has his dollar. His $13 bill. Dollar bills, y'all. All right. Oh.
Edward Shelton. It's case number 2025 CR 15. Brett Sweeney appears for the state of Kansas. James Watts is defense counsel. Mr. Shelton now appears from a Department of Corrections Zoom location. Docket notes indicate that this matter at one time was set for jury trial and pretrial conference. Defendant did not appear for the pretrial conference. The case was taken off the jury trial docket. Eventually, Mr. Shelton was brought back before the court, or at least a proceeding was scheduled to have him back before the court, but he was in DOC custody at the time at Lansing. And the court decided to schedule a status and scheduling conference for today with Lansing Correctional Facility to be notified. And the court obviously appreciates their cooperation in getting Mr. Shelton on the meeting. What is the current status of the case now, Mr. Watts?
Your Honor, I've discussed with my client an offer made by the state. My client believes he's ready to accept that offer. I think his concern, and I think understandably so, is there is also a motion for judgment on his bond pending before the court right now. He was asking about what his current bond was. It looked like it was $7,500, although that at one point was revoked and forfeited. The state has made what we think is a very fair and reasonable offer on it, and one that, believe it or not, with my client's history, and there's quite a bit of it, he has a possibility of getting probation on. He really wants to be able to have some time to demonstrate that he can be successful on that probation, to build something that he can show the court that he can do that probation. So I think it's likely this is going to be resolved by plea, but I think my client would prefer to figure out what his bond status is and his status as far as the detainer on his placement in the Department of Corrections before he goes forward on it.
What is his expected out date on his current case that he's serving time on?
December 18, Your Honor, according to Casper. I think I'm talking to my client. He thinks sounds about right. Is that correct?
Yes, that's correct.
Well, his bond status is currently he doesn't have one due to his failure to appear on May the 16th. Where was he on May the 16th?
Was incarcerated
Where?
in Sedgwick County. I went in on April the 20th to Sedgwick County, and I've been here ever since. And I notified my bonds lady about the court date coming up and everything. I tried to stay in contact with everybody about that.
Well, at the last bond hearing, it was determined that you may have been in the Sedgwick County Jail, but that was unconfirmed.
Okay, 4/20, I went to Sedgwick County Jail, and I've been there all the way. This case was 10 months.
And Mr. Sweeney, can your office verify that that's true?
Your Honor, I do believe that that's accurate. I haven't checked to double check and verify that, but I think that is accurate, given all the information that I have.
Well, the court at this time then, based on what apparently is the county attorney's office concession, will set aside the current motion for judgment on bond. That's never been granted. That was taken under advisement earlier so that further investigation could take place. The court will dismiss the motion for judgment on bond. Mr. Shelton, being in jail somewhere else is not a very good reason not to show up in court. I mean, you understand the inherent problems with that?
Yes, I do, Your Honor.
But also, there is essentially an impossibility for you to appear in our court when they won't let you out to do so.
Correct.
Our court was not aware that Sedgwick County Jail needed to be cut in on a Zoom meeting, or we could have arranged that, but we didn't know. So perhaps the communication with your attorney would have been the better course of action. The bondswoman may have been notified, but if your attorney doesn't know, he doesn't know to set anything up.
Yes, Your Honor.
The bond is considerable. If he has earned his release at Department of Corrections, the court at this point believes that unless the bondswoman doesn't want to stay on the bond, the court will reinstate it in the amount of $7,500. Understanding that while I'm reestablishing a $7,500 bond, Mr. Shelton, I think under the circumstances, you're the bondswoman that handled the case before, which is Sarah Recheck. She doesn't have to stay on the bond.
Yes, I know.
If she doesn't, then you'll have to post a new bond with somebody else.
Correct.
We'll
And we can
reinstate
stay in
a
contact
bond
with her.
in the amount of $7,500.
Okay.
All right. His bond status is now clarified, Mr. Watts. So what else?
Well, Judge, in discussion with my client, I believe we've discussed at great length, at some length, the plea offered by the state. I think it's one he's willing to accept. I think the question is, do we do it today or at some later date?
And we would postpone it for what reason at this point?
Well, as I said, my client wants to be able to get out on bond if the detainer is going to be lifted, that's currently in place, to get out on that bond and get his life reestablished so that he has something to show the court at time of sentencing, should a departure be necessary. Believe it or not, and amazingly enough, and I won't mislead the court or say otherwise, there is considerable criminal history. However, none of it is person felony and none of it is prior drug sales. So he may well qualify for a potential Senate Bill 123.
Just because it's not on paper as a person felony does not mean that people were not significantly harmed by his actions or affected in some way by his actions. Just because he didn't batter someone in the process of robbing them, it doesn't make it any more acceptable.
On a level 4, plus the 2 theft charges, which is what the state has offered and my client has accepted, at least in principle. The question is, when do we enter that plea? I've explained to my client that even if we entered the plea today, it would likely be late January before sentencing would be done, and that would give him some opportunity to do exactly those things: get out in the community, establish a residence, establish some work history, and be able to demonstrate to the court that he can do probation successfully.
What is the state's position here, Mr. Sweeney?
Your Honor, I don't know that I have an objection to the continuance request. I think Mr. Watts is accurate in his recitation of what the plea offer is. And I feel a little bit better knowing that when he's released, he'll be on parole supervision. So, you know, if he goes astray of that, I think they're watching him as well. So if he goes astray of that, he's only hurting himself with relation to this case.
All right, Mr. Shelton, under Kansas law, you have to be tried if you're incarcerated within 150 days. If you're not incarcerated within 180 days, you are about 3 months into your speedy trial time at the time that you defaulted on your appearance obligation. So all of this time that's accrued subsequent to your failure to appear is attributable to you and not the state.
Yes.
However, before this court would consider a continuance of your case, this court must be assured that you're waiving any right to a speedy trial that you might have, and understanding that you do have a right to have your case tried within the timeframes that I mentioned earlier. Would you be, do you need to talk to your attorney about waiver of speedy trial right, or are you in a position to waive your right to a speedy trial in the case?
I could waive my right. I understand all the speedy trial rules.
All right, and so this postponement that you're seeking, essentially, you're waiving any speedy trial time accruing against the state until the court rules otherwise.
Yes,
Is
Your
that
Honor.
correct?
Yeah, that is correct.
All right. Court finds that the defendant has made apparently a knowing and voluntary waiver of his right to a speedy trial in this case. Therefore, the court will grant the requested continuance. I do question, Mr. Watts, how much time realistically after release on post-release supervision before he can really demonstrate that he's got his act together?
Well, Judge, I'm not sure I can answer that entirely. Obviously, just getting out of Department of Corrections, he's going to have some difficulty getting a job, getting a residence, and establishing those things. The flip side of that, of course, Your Honor, is we want to get this matter resolved, and preferably before the first of the year. We'd rather do this sooner rather than later. If his release date is on the 18th, perhaps we could set a court date for what we'd expect to be a plea that week right before first of the year or shortly after the first of the year.
Yeah, rather than allowing him to accrue time served for a couple of months until his sentencing, being that he's presumptive prison, let's put him out there on a bond for him to be able to get a job that he'll have to leave in a couple of months, a home or apartment that he will have to leave for a couple of months at least. It doesn't make sense to me. Just sit the time and start your life over when you get out of the pokey.
And I'm a little bit concerned about what happens to him when he's released from DOC custody, presuming they get notice of the fact that the detainer in this case has been removed. He may have to go back to the Butler County Jail to get bonded out again. I'm not 100% sure what's going to happen to him upon his release from DOC custody, given his current status in the case. And I don't know what the bondswoman's position would be here about reinstating his prior bond. He may have to post a new one, and I don't know if he's got the financial resources to do so. I do have that concern. I'm going to address my assistant for a moment. Mandy, I think I'm more comfortable with a January setting than a December one. What would you suggest as far as an appropriate date for a January setting?
Okay, let me look real fast.
And it can be any time during the calendar month that we can suggest. Remembering that Mr. Watts has trial commitments most weeks.
Which calendar? The Mayan calendar, the Aztecs, the Gregorian calendar? I mean, you got to be a little more specific, Ricky.
And I don't want to interfere with any of the judge's dockets.
Yeah, I have double trial commitments the week of the 5th and 6th, Monday the 5th.
I'll bet you do.
January 12th at 11 a.m. Would that work?
Judge, I'm in front of Judge Hart. It looks like a trial week starting on Monday that week. I'm not sure why.
Okay.
I'm in front of Judge Hart all day that day,
All right.
assuming they go.
Okay, okay. We're kind of limited there. Let me see. January 15th?
Afternoon preferably. Morning's pretty full.
Afternoon, I'm good. My morning is booked.
The afternoon is open, so you want to do it at 1:15?
Yes, ma'am.
Yes, Your Honor.
All right, the court will set Mr. Shelton's next appearance for 1:15 p.m. on Thursday, January 15. If you're out in the community, Mr. Shelton, you'll need to appear at the Butler County Judicial Center in El Dorado, Kansas, or James Watt's office. One of those two locations. This will be a Zoom proceeding, and I want you either in Mr. Watt's office or at the Judicial Center. Okay.
He looks like the Joker. The one that went crazy. He seriously does. Like when he's got his head down, and there's one point, there's one spot where I'm going to point out later that his eyes do something really freaking creepy.
Okay.
No other location.
Okay.
So Shelton is set for 1:15 p.m. by Zoom, Thursday, January 15. I'm going to list it as plea hearing.
And if I may, Your Honor, Mr. Shelton, my office number is 316. When you
Okay.
get released, get a hold of me. Let me know where you're at, where you're going to be staying, and all those arrangements so I can stay in touch with you.
Okay.
Shelton, I'm going to want to know on January 15 where you are residing and where you are working.
Okay. Yes, Your Honor.
And if you're in any type of rehabilitative program, what program that is as well.
Okay.
All right.
Thank
Good
you.
luck. I hope you're released when your release date comes up and that you have an opportunity to reestablish yourself in the community before our next hearing.
Okay. Thank
Okay,
you.
Thursday, January 15, 1:15 p.m. by Zoom with the defendant either in Mr. Watt's office or at the Butler County Judicial Center in El Dorado.
I have it all written down and the address to the Judicial Center. Thank you.
Excellent. Mr. Sweeney, anything further at this time?
No, Your Honor.
Mr. Watts, anything further?
No, sir. Thank you.
Very well. If there's nothing further at this time, the Anthony Shelton matter will be in recess, and we can end the meeting for all at this time. All right, Anthony Shelton.
Yes.
Okay. It's the state of Kansas versus Anthony Edward Shelton, case number 2025 CR 15. Cheryl Pierce appears for the state. Anthony Shelton from the jail Zoom location. I'm not sure exactly why you're here, Mr. Shelton. The court's docket notes indicate that on November the 24th, the defendant seeks continuance to get beyond a DOC release date, which was supposedly December the 18th, which apparently you were released from DOC on that date.
Yes. And you reinstated my bond. Watts was there. We did have the Zoom meeting while I was in Lansing. You reinstated my bond. I'm not really sure either. I assumed that I was going to get out either from Lansing or whatever, but then there was no bond when I got here. So I'm kind of confused.
Well, you've got a court date in this court on January 15, 2026 at 1:15 p.m. You're ordered
Yes.
to be either in Mr. Watt's office, who's your lawyer,
Yes.
or the Judicial Center Zoom location. Bond reinstated at $7,500 cash professional surety. The state was convinced that you were in the Sedgwick County Jail at the time of previous default.
Correct.
And that plea is likely, though I can't commit you to that today, Mr. Shelton, on January 15. From the court's docket notes, you are on bond in this case.
Yes. Should be.
I don't know if you have any other holds.
No, I do not.
Well, okay. The jail will know that, but I will announce that your bond was previously reinstated at $7,500 cash or professional surety with Owens bail bonding.
Correct.
So you're still under that bond in this case, and you're subject to being released on that
Okay.
bond on this case.
Correct.
Mr. Shelton, remember your court date and time?
I do. January 15th. I've got it all ready to go
What time?
at 1:15. I
Where
do
you
have
need
a
to be? Where you need to be?
either in the jail at the Zoom or at my attorney's office.
Okay. Not
I
the
also
jail. You'll need to be at the Judicial Center.
okay. That's okay. When I was in Lansing, you said I had to be one or the other, either with my attorneys
Yes.
or the,
Judicial Center or Watts's office.
right? And I did, the only thing you asked before, I do have a home address. I'm on parole and everything. You said be sure to have an address when I came to the hearing. I never gave it to anybody, but I do. I have a house I've had for 2 years. I have a home address and everything. I don't know if that matters at this point, but
State it.
616. That's also
1616
616.
616. Okay.
Yeah, 67203 is the zip. I'm on parole to that address. I've had that house for about 2 years.
Yeah, that's about, isn't it?
It's right there at the corner, right when you get off the first house or the second house on the corner.
Well, hopefully you'll show up for court and we won't have to send law enforcement to that address to get you.
Not a problem. I will be
All
here.
right. Mr. Shelton, I think this concludes our business. You have a lawyer, you have a court date, and you're on bond.
Okay, thank you so
I can
much.
understand what happened here, because sometimes the communication between agencies fails a little bit, but you're on bond. I can announce that for our jail that you have been reinstated.
Okay, thank you so
All right.
much.
We'll see you in January, Mr. Shelton.
I'll be here. Thank you.
CR 15. Anthony Shelton now appears in the office of his attorney, James Watts. Brett Sweeney appears for the state of Kansas. This matter came before the court last on December the 19th. At that time, a plea hearing was set for today, with the defendant ordered to appear at Watts' office or the Judicial Center, and the court released him back on his previous bond at that time. What announcement is made at this time, Mr. Watts?
Your Honor, pursuant to discussions with the state, it's my understanding the state would amend count 1 to allege a level 4 possession of methamphetamine with intent to distribute as a level 4 drug felony. My client would plead guilty to that level 4 offense, as well as count 2 felony theft and count 3 a class A misdemeanor theft. The remaining counts would be dismissed.
All right. Mr. Sweeney, as Mr. Watts announced consistently, with your understanding as to how this case would be handled?
Yes, Your Honor.
All right, Mr. Shelton, your attorney has made an announcement that you would resolve your case by entering a plea to amended count 1, a level 4 possession of methamphetamine charged with intent to distribute. You'd also be pleading guilty to count 2 in this case, which apparently is a felony theft charge, and also to count 3, a misdemeanor theft charge. Is that indeed your intention?
Yes, Your Honor.
All right. I've got a number of questions I need to ask you regarding the taking of a plea of guilty. If there's anything asked of you that you do not fully understand, I will give you the opportunity to confer privately with your lawyer, Mr. Watts, at any point if you need further advice. Just let the court know if you need that time for conference, okay?
Okay, thank you.
State your full legal name for the record.
Anthony Edward Shelton,
How old are you right now?
54,
What's the highest level of education that you've attained?
a year of college.
Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, sir.
Have you ever been adjudged to be mentally ill?
No,
Are you currently under the influence of alcohol or any drug?
no, sir.
Are you currently taking any type of prescription medication?
Ibuprofen, that's it.
Okay.
No prescription, no, sir.
So as you participate today, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
Yes, sir.
Do you understand the nature of the charge in count 1, especially as amended possession of methamphetamine with the intent to distribute?
I do.
You understand the nature of the charge of felony theft as charged in count 2?
Yes,
And do you understand the nature of the charge of misdemeanor theft, which is charged in count 3?
sir.
You understand that when you enter pleas of guilty, you are admitting these very acts that have been charged by the state?
I do.
Yeah, meth's kind of hard on the body, hard on the wallet, kind of hard on the family and the community. Basically, it ruins everything.
Mr. Shelton, do you also understand that when you enter pleas of guilty, you're giving up any legal defenses that you might have had to those charges?
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your lawyer, Mr. Watts, and that at a trial you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case under oath, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes, sir.
You understand that when you enter pleas of guilty, you give up these valuable trial rights that the court has described.
Yes, sir.
Are you also aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter pleas of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
Mr. Shelton, you understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgments of conviction after you enter such pleas.
Yes, sir.
Are you aware of the sentence that could be imposed as a result of this set of guilty pleas that you're attempting to make?
I am, yes, sir.
Let's go over those. The level 4 drug grid crime in the most favorable criminal history category of I, you could receive as little as a 14-month sentence. It appears that your attorney is putting that grid before you. Is
Yeah.
that correct, Mr. Shelton?
Yes,
Do you see where the 14 months comes from?
I do.
If you look over at the other end, though, in the most non-favorable criminal history category of A, you could receive as little as or as much as a 51-month prison sentence. Do you see that?
Yes, sir.
So the sentencing range on level 4 drug is 14 to 51 months in prison, depending on your criminal history. As you participate today, we do not know with certainty what your criminal history is, Mr. Shelton. You better than anyone else here should really know what your own criminal record looks like, but that would be researched by the Court Services Department. And based on the outcome of their research, as of the date of sentencing, that determines where you fall along the level 4 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
Okay. You also understand that you could receive up to a $300,000 fine for that offense?
Yes, sir.
Okay. Turning to the non-drug offense grid felony, the level 9 felony theft in count 2. In the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. But again, in the worst criminal history category of A, you could receive up to a 17-month sentence. So the sentencing range on the theft charge is 5 to 17 months in prison, depending on your criminal history. You understand that?
Yes, sir.
Also, do you understand that you could receive up to a $100,000 fine for that offense?
Yes, sir.
Okay. Turning to the charge count in count 3, which is Class A misdemeanor theft. Do you understand that a Class A misdemeanor in Kansas is generally punishable by up to a $2,500 fine and up to a year in the county jail or both?
Yes, sir.
Shelton, do you understand the differences between consecutive and concurrent sentences?
I do.
Consecutive means boxcard, back to back. You serve all of one before you start serving another, which obviously results in a longer incarceration sentence. Concurrent means that they run all at the same time. When you're serving one, you're serving others, and therefore obviously resulting in a shorter incarceration sentence. Mr. Shelton, do you understand that generally it's up to the court to determine whether your cases or your charges run consecutively or concurrently?
Yes, sir.
Okay. In addition to any fines that could be imposed, Mr. Shelton, do you understand that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and
Yes.
restitution to victims, if any are owed, as part of your sentencing orders?
Yes, sir.
Do you also realize, as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing?
Yes, I would understand that.
You also understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances. Do you understand
Yes.
that?
Yes.
Okay. You also understand that the Kansas Sentencing Guidelines Act, Mr. Shelton, is much more than a grid page like you've likely had shown to you today. It's an entire book of sentencing rules and laws. Do you understand that if any special rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you
Yes,
understand that?
sir. I do understand that.
Okay. Going back to the drug offense grid, Mr. Shelton, I want to make sure I point out to you that the entirety of the level 4 drug line is presumptive prison under Kansas law. Do you understand that?
Yes, sir.
If you have a person felony on your record at time of sentencing, you would be outright presumptive prison. Do you understand that?
Yes, sir.
And you further understand that grid boxes E through I are what we call border boxes, which means that they are presumptive prison, but the court, without a departure finding, can impose a non-prison sanction if certain findings are made, usually based on community-based treatment. You understand that?
Yes, sir.
And that's not a guarantee. You understand that, Mr. Shelton?
Yes, I do.
Okay, all right. Now, Mr. Shelton, have you had an adequate opportunity to discuss fully all of the implications of these pleas and all your legal matters with your attorney, James Watts, before proceeding here today?
Yes, I have.
Do you want any more time with him privately now before we go any further?
No, sir, I don't think so.
Are you satisfied with the services and advice given to you by your attorney?
Yes.
Now, these guilty pleas that you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentence or any other
No.
type of threat or
No, sir.
promise?
They have not, no, sir.
Mr. Shelton, is there anything else that was part of this plea agreement deal that hasn't been accurately discussed on the record already?
No, sir.
Okay. You understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So let me ask you formally, how do you plead to the charge in count 1, a level 4 charge of possession of methamphetamine with the intent to distribute?
I plead guilty.
And to count 2, felony theft?
Guilty.
And to count 3, misdemeanor theft?
Guilty.
According to the state's charging document, all of these things happened almost exactly 1 year ago on January 14 of 2025. Is that when they happened?
Yes, sir.
And they happened somewhere in Butler County, Kansas. Where was it?
I was coming back from my landlord's on, I was coming back to Wichita, so I was going through Andover.
Okay. All right. I want to move to count 2 first. If you're pleading guilty to felony theft, what is it that you took?
It was a truck. I didn't take it, but I was buying it from somebody that took it.
And it's charged, Your Honor, as a possession of property stolen by another.
Okay. Did you know that the property had been stolen by another, Mr. Shelton?
Yes, I was pretty certain it was.
All right. Did the value of this truck, was it more than $1,500?
I don't know. Probably, yes.
Okay. You're not disputing that it was?
No, I'm not.
Okay. Count 3 involves a misdemeanor theft on the same date, presumably the same place. What is the item stolen then that leads to count 3?
It was the tag on the vehicle.
Okay. That tag belonged to another person and you knew it didn't belong on that vehicle?
Yeah, I did know that it did not belong on that vehicle. I was told that.
All right. According to information, count 1, you possessed methamphetamine on that date.
Yes, it was in the truck.
Okay. And there was at least, well, how much methamphetamine was there?
Almost 2 ounces, a little under 2 ounces.
Okay. How many grams would that be approximately?
40, I'm not sure.
The charge is 47 grams, Your Honor. I don't think my client had actually measured it, but we don't dispute that number.
Very well. Is that correct, Mr. Shelton?
Yes, sir.
Okay. So do you now freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for possession of methamphetamine with the intent to distribute, a level 4 drug felony in count 1, level 9 non-person felony theft in count 2, and misdemeanor theft in count 3?
Yes, sir.
Mr. Watts, do you know of any legal reason why the court shouldn't accept your client's plea?
I do not, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
All right. Mr. Shelton, are you aware of a legal reason or any other good reason why the court shouldn't accept your guilty pleas here today?
No, Your Honor.
Court will accept the guilty pleas made by defendant Shelton and finds that those pleas are made voluntarily. He has an understanding of the nature of the charges against him and the consequences of the plea, and a factual basis for each charge does exist. Court finds the defendant guilty and adjudges him therefore convicted of possession of methamphetamine with the intent to distribute, a level 4 drug felony in count 1, count 2 felony theft, a level 9 non-person felony, and then count 3 misdemeanor theft, a class A misdemeanor. The other charges of the information are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Mr. Shelton's criminal history, and the court will set an appropriate date for sentencing. Mr. Watts, I'm looking at Monday, March 16 at 11 o'clock in the morning.
I can do that, Your Honor.
Court will set Mr. Shelton's sentencing for Monday, March 16, 11 o'clock a.m. Court orders Mr. Shelton to appear at the Butler County Judicial Center in El Dorado, Kansas. Report into court security on that date, Mr. Shelton, and you'll participate by Zoom from the Judicial Center's location at that time.
Okay.
So you at the Judicial Center, 11 o'clock, Monday, March 16. I might suggest you come about 15 minutes early to make sure you get checked in through security and to the right location so that we can start promptly at 11 o'clock a.m.
Yes, sir. I will.
Court also orders the defendant, as a condition of his continuing bond, to fully participate in the pre-sentence investigation process, including timely completion of all assessments. Mr. Shelton, you may be asked to do one or more assessments. Most likely you'll be asked to do a risk needs assessment. You very well could be asked to do a substance abuse assessment. It's up to you to make sure that those get scheduled and completed prior to sentencing so that we don't have any delays in your sentencing date. If you
Okay.
don't follow through on these things, the court will likely hold you responsible on March 16 when we come back before the court.
Yes, sir.
So I might suggest, Mr. Shelton, that you either call from your attorney's office or go on over to the court services office following court, check in with that office, follow whatever direction they give about starting your pre-sentence investigation process.
I will.
Okay. And again, as alluded to earlier, the court will continue Mr. Shelton under his current bond. I do expect you to be on time, though, next time. Okay, Mr. Shelton?
Yes, sir.
All right. Mr. Sweeney, is there any other Shelton-related matter that we need to address at this time?
No, Your Honor.
Mr. Watts, is there anything further from your perspective?
No, Your Honor. Thank you.
Okay, Mr. Shelton, do you have any questions about what we've done here today?
I don't think so. I think my
Anything-
attorneys
If
answered
anything
them all.
comes up, Mr. Watts is a very experienced attorney. I'm sure he can answer any question that might arise.
Okay, thank you so much.
Go ahead and make that immediate contact with the Court Services Department today.
I will. Thank you,
All
sir.
right. There is nothing further then. The Shelton matter will be in recess at this time, and this meeting may be ended for all. State of Kansas versus Anthony Edward Shelton. It's case number 2025 CR 15. Amber Norris appears for the state of Kansas. James Watts is defense counsel. Defendant Shelton appears at a court security monitored Zoom location at the Butler County Judicial Center.
Now, I am not even kidding you. I know he has naturally dark eyes from how deeply inset they are. But there is a point where Judge Ricky is talking and his eyes change. They go completely black, like 100%. It's almost like watching a demonic takeover. It is creepy. This guy creeps me out.
This matter comes before the court at this time for sentencing. The court's docket notes indicate that the defendant appeared before this court on January 15 of 2026. At that time, he entered guilty pleas to amended count 1, a level 4 possession of methamphetamine with the intent to distribute. Count 2, felony theft, a level 9 felony, and count 3, class A misdemeanor theft. A pre-sentence report was ordered with sentencing set for today. Court has received a completed pre-sentence investigation report compiled by Tyler Winter, pre-sentence investigator. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in that report?
No objection, Your Honor.
Any from the defense, Mr. Watts?
Your Honor, I've reviewed same with my client. We believe it is correct, but have no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Ms. Norris, are you aware of any legal reason why sentence should not be pronounced in the Shelton case here today?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir. Thank you.
Mr. Shelton, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing at this time?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
At this point, no, Your Honor, although I will tell the court what is characterized as the lead count in this case is confusing because it appears to be on the one hand presumptive prison and on the other hand mandatory drug treatment. I would note that count 2 is also a mandatory drug treatment under Senate Bill 123. And I've been going through the desk reference manual to see if I can reconcile those two things.
When Mr. Watts said drug treatment, dude's eyes went more black. And they're going to do it one more time. I'm telling you, it's seriously like watching a demonic possession.
It appears he's going to be mandatory drug treatment under Senate Bill 123. And assuming the court does not disagree with that, then no, I don't anticipate any departure motions.
Mr. Watts, I'm not sure the proper question is whether the court agrees with it or not.
Okay, I'm going to try going back just a teeny bit. It's when Watts is talking and you can see the dude's eyes and he's got his bags under his eyes. But it really does jump dramatically darker.
And finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Ms. Norris, are you aware of any legal reason why sentence should not be pronounced in the Shelton case here today?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir. Thank you.
Mr. Shelton, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing at this time?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
At this point, no, Your Honor, although I will tell the court what is characterized as the lead count in this case is confusing because it appears to be on the one hand presumptive prison and on the other hand mandatory drug treatment. I would note that count 2 is also a mandatory drug treatment under Senate Bill 123. And I've been going through the desk reference manual to see if I can reconcile those two things. It appears he's going to be mandatory
It was like, I don't know. To me, it was like a veil that just dropped.
drug treatment under Senate Bill 123. And assuming the court does not disagree with that, then no, I don't anticipate any departure motions.
Mr. Watts, I'm not sure the proper question is whether the court agrees with it or not.
Yeah.
The question really is the court compelled to follow it? At this, I tried to reconcile, I think, all of the difficult things that were raised by this pre-sentence report. And I did have a discussion with Ms. Winter last week, even regarding what should be regarded as the primary offense in this case. However, at this point, the court is satisfied at this juncture that apparently what has been presented to the court is correct, unless counsel has some different argument they wish to make, and the court intends to proceed further accordingly.
Understood, Your Honor.
Very well. Thank you, Mr. Watts. I appreciate the discussion and the difficulty that I think we've all had in sorting out this particular case. Again, the court adopts the criminal history as stated in the report. We are proceeding as if that the primary crime is a level 9 grid box E on the primary count. Are there any victims or members of a victim's family who desires to address the court in relation to this sentencing? Court finding no such persons present. This time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Shelton, beginning with Amber Norris on behalf of the state of Kansas.
Well, I don't know. As far as an appropriate sentence, I'm kind of thinking there needs to be holy water involved. A baptism, maybe? Yeah, I know. Well, it looks creepy. I mean, he the whole Heath Ledger look in the first episode part didn't help him any. Like, this guy is like a movie character. Oh, you can't script this stuff. Oh, have a good night, Courtroom Files. Thank you so much for coming and hanging out with us. I really appreciate it. I hope you come back and see us again.
Your Honor, regarding count 2, the felony theft, would ask the court assign defendant to 10 months in the Department of Corrections. Defendant would be able to earn up to 20% good time credit and will be subject to 12 months post-release. Your Honor, it does appear there are 2 special rules that apply, which make this case presumptive prison. Basically the prior thefts and the crime committed while on felony bond. But Your Honor, this is a mandatory SB 123. So we would ask the court assign defendant to up to 18 months community corrections probation with all standard and PSI recommended probation conditions. Defendant has earned 3 days of jail time credit. And regarding count 1, 15 months in the Department of Corrections. And regarding count 3, that is a misdemeanor theft, 12 months in the Butler County Jail. Your Honor, there is $400 in KBI lab fees to be assessed to the defendant, standard costs and fees of the action as well. SB 123 fees of $300. There is no request for restitution outside of the KBI. All standard and PSI recommended conditions, including obviously the drug alcohol treatment, employment, Defendant was notified at time of plea of his notice of duty to register. So we would ask the court remind him of same today. Court will need to address court-appointed attorney's fees as Mr. Watts is appointed. And Your Honor, we would ask that this case run consecutive to Sedgwick County District Court case 24 CR 1929. He was on bond in that case at the time of the commission of this offense. Otherwise, Your Honor, I don't think the state has any further recommendations for the court.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate sentence.
Your Honor, similar to Ms. Norris, would recommend on this, on the primary count, count 2, the standard range of 10 months with the post-release good time credits and probation duration is noted, as Ms. Norris noted, this is apparently a mandatory drug treatment program case as well. As to count 1, it's likewise, had that been a lead count, would also be a Senate Bill 123 case, although given the status of count 1, that's really redundant and not really applicable. We'd recommend the standard mid-range of 15 months at that point of that case, as well as on count 3, a 12-month on the A misdemeanor theft of property. Would ask those cases run those sentences run concurrent with each other. Place him on probation with community corrections with the normal and usual conditions that go in a case such as this one. I have emphasized to my client the absolute necessity of fully participating and being very diligent in his probation and the Senate Bill 123 treatment programs. That's all I have, Your Honor. Thank you.
And your attorney fees and the representation of this client would be how much, Mr. Watts?
Judge, this was billed to bids or will be billed to bids at $13.20.
Thank you. At this time, the court will address the defendant, Anthony Shelton, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
Yes, Your Honor. I just want to say I was released from Lansing in December. We set this off a little bit, so kind of gave me a little bit of rope to see what I was going to do with it. But in that time, I've registered in, he was telling me I didn't have to, but I registered in Butler County, then registered in Sedgwick County. Right after that, I started treatment myself. I have a letter here from treatment for you. Instead of just doing the outpatient treatment on the group, I'm taking individual. So instead of 1 a week, I'm doing 2 a week. I'm doing an individual and a group counseling. I've never really had to do that before, so I think I need it. I think it's something that's I have to do. I don't know if this treatment would be considered for that. This is just something I had to get into before, as soon as possible. So I did. I've also got mental health stuff set up through my treatment to do. That's all part of this too. I'm doing good on parole. I've got a job. I've got a house. I've spent the last 3 months really trying to get on my feet and get things going. So far, I'm doing really well. I don't know. I have to make a change. I mean, I'm not a bad person. I'm not, I have a drug addiction that's pretty bad, and I wouldn't hurt anybody else. That's why I've got all these charges, but never had a personal felony. I'm nonviolent completely, but I do have to change. I'm tired of going in and out, and there's other factors with family and stuff that's involved that it's that time. I can't do it anymore.
Anything else, Mr. Shelton?
I don't think so, no.
Well, the court will pronounce sentence shortly, but I think some remarks are appropriate here. Quite
Watch his
frankly,
eyes.
Mr. Shelton has a shocking criminal history.
Watch his eyes.
Anything else, Mr. Shelton?
I don't think so, no.
Well, the court will pronounce sentence shortly, but I think some remarks are appropriate here. Quite frankly, Mr. Shelton has a shocking criminal history. 31 prior felonies, 46 prior misdemeanors. Quite frankly, Mr. Shelton, the court finds it incongruous with community interests or any interest or fair notion of justice that this court would be forced to place you into a community-based alternative under current Senate Bill 123 based drug treatment laws, which currently exist, which essentially compels, in this case, a community-based alternative. Mr. Shelton, you should be in prison on this, not in a community-based alternative. Recognizing that, the court will formally pronounce sentence at this time. The court hereby establishes count 2 as the base sentence in this case for the offense of felony theft, a severity level 9 non-drug, non-person felony, in which the defendant has a criminal history score of E, thus placing him in grid box 9E. The court hereby sentences the defendant to the aggravated term of 11 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. Regarding the additional offense in count 1, for the conviction of possession of drugs with the intent to distribute, a severity level 4 drug non-person felony, in which the defendant has a criminal history score of I, the court hereby sentences the defendant to a term of 16 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 24 months of post-release supervision. The court imposes no fine on that count. It is the intention of the court to run counts 2 and 1 consecutively with one another. The court is aware of the double rule, which applies here. The court essentially will enter an order of a 22-month prison sentence, which is twice the aggravated term as imposed on the primary count. So this is a 22-month DOC sentence in this case. With that announced, the court does find that based on the high probability of Mr. Shelton having a substance abuse disorder, as indicated by the SASE instrument in this case, further, that there's a high risk assessment score on the LSCMI, the court must recognize that this is a mandatory case for Senate Bill 123 community-based treatment under current statutory authority in the case. Again, with the court expressing all of its regrets earlier, ultimately, the court determines that mandatory does mean mandatory in this case, and that in the view of the court, an undeserving defendant is going to receive the benefit of this law for an initial community-based alternative in the case. Therefore, the court will grant the defendant up to 18 months probation duration to be supervised by community corrections.
Oh my goodness. Those words hurt. I betcha. Wow, an undeserving defendant is going to receive the benefit of the program. Oh, Ricky, you don't like him. And look at how freaking evil he looks right now. It's like he's seething with rage, but he's keeping it under the blanket. Oh, but he just looks so evil.
As part of up to 18 months of drug treatment, which is required by law in this case. Conditions of probation will include the defendant observing all laws, reporting to an officer as directed, submitting to and following through on recommendations made by a qualified substance abuse evaluation. He shall not possess or consume alcohol or illegal drugs while on probation. At his supervising officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to program requirements, gain and maintain employment successfully throughout his probationary term, notify his supervising officer of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. He shall register as an offender, a drug offender under the Kansas Offender Registration Act, abide by any curfew or travel restrictions imposed by his officer. He shall complete Senate Bill 123 treatment and follow all aftercare recommendations, not have in his possession firearms or dangerous weapons. He is not to associate with any disreputable characters or places, which Mr. Shelton means anywhere you could be offered drugs or get drugs. Community corrections is authorized to require the defendant to meaningfully participate in the MRT program. The court will assess $400 to the KBI laboratory, $193 felony docket fee, the community corrections fee, correctional supervision fee, $300 in total reimbursement to the Senate Bill 123 treatment program. However, given the current status of this matter, the court cannot determine that Mr. Shelton, recently released from DOC custody, has the financial resources to pay bids amounts, and the court will waive the application fee and bids attorney fees in this case. Court will require the defendant to pay at least $75 a month on these obligations. Furthermore, this court is empowered as a condition of probation to order up to 60 days in the Butler County Jail. This court has rarely seen a property crime or drug case that calls for incarceration more than this one does. Mr. Shelton, your track record is that you steal to get what you want. You've done it again here. It would not appear to this court, just looking at your overall criminal history and even the circumstances of this case, that it's drugs that's really the issue. The legislature would disagree based on the outcome of some assessments and testing that you've done, but you're a career criminal and you're a career thief. This court is going to order you to serve 60 days in the Butler County Jail as a condition of probation. I do note that you have 3 days prior credit, so the court will order you into custody at this time to serve 57 consecutive days without release privileges in the Butler County Jail before being released into your community corrections program. And I've already dealt with the issue of jail time credit. There does not appear to be any restitution to be paid to a victim in this case, so no such restitution order will be made outside the reimbursement to the KBI laboratory. Again, I want to remind the defendant of his continuing obligation to register as a drug offender under Kansas law. At some point in the future, Mr. Shelton, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. Before I address appeal rights, I want to make sure the record is clear. I've already imposed the felony sentence in this case, and that the 12 months that the court will impose on the misdemeanor count will run concurrently with the time imposed on the felony counts. And that is a 12-month duration sentence on the misdemeanor. Addressing rights to appeal in this case, Mr. Shelton, you may have the right under certain circumstances under Kansas law to appeal a conviction to an appellate court having jurisdiction. And if you are unable to pay the cost of an appeal, you, the defendant, may request the court to appoint a lawyer to represent you on appeal and to direct that you be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you there's prohibitions against a convicted felon possessing a firearm, and if there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. All right. Ms. Norris, are you aware of any other sentencing related matter which the court has not fully addressed?
Don't believe so, Your Honor. Thank you.
Mr. Watts, are you aware of anything further?
No, sir, thank you.
Mr. Shelton, you have any questions about the court sentencing orders?
No, sir.
If indeed you are motivated this time to stay out of trouble and complete treatment, I wish you success in that regard. I think you can even tell from the court's remarks today that you are an extremely fortunate individual, that you happen to fall into a category under the law that kept you out of prison, despite the fact that there were two special rules here which indicated that you were essentially going to be in prison. The Senate Bill 123 law apparently trumps those, and the court has ruled accordingly. I will note for the record that I think whether it would be a matter of discretion or not, or whether it would be mandatory under the law, any time imposed here would run consecutively to Sedgwick County case 24 CR 1929. I did want to announce that for the record. I will order at this time Mr. Shelton into the custody of the representatives of the Butler County Sheriff's Office until his custody can be transferred to the jail to serve the remaining balance of the 60 days imposed, which according to the court would be 57 days due to the 3 days prior jail time credit. Ms. Ashenfelter, she's a representative here from Community Corrections. What direction would you give Mr. Shelton at this time?
Your Honor, if we can do a brief breakout room, I can go over some requirements with him before he goes to jail.
Very well, Mr. Shelton. We're going to leave the Zoom meeting open after we recess court to allow you an opportunity to confer with Ms. Ashenfelter from Community Corrections. Follow whatever direction she gives under the circumstances.
Yes, Your Honor.
If there's nothing further then, the Shelton matter will currently be in recess at this time, and we can stop recording.
Well, there you guys have it. 5 hearings, a whole FTC. Yep. I don't know. I don't know if we want to encourage him to do things that cause his blood flow to, you know, make his pupils dilate and make him look even creepier. I don't know. I know. It did. It did. It was over an hour for the case. I swear. Oh, you suck so bad. I've got another set, but it's an hour long. I was thinking about running it during the day tomorrow. Well, if you guys are up for more, I can definitely put more on. I kind of want to. I kind of want. I need to do this. I need to do this. So I will put the case on. The case is it's another FTC block, but it's 2 defendants. It's the craziest duo you'll ever see, and you wouldn't even believe the charges unless you heard them for yourself. So I love you guys so much. I'm gonna put the cases on, and then I'm gonna be doing this.
And his co-defendant, I believe, is
He has a co-defendant?
I shouldn't have. Sorry, it's Young and Pickert's your next 2 on your list.
Yeah. I didn't
Sorry.
figure out. Okay, so Young and Pickard are co-defendants, and then Scott is a co-defendant with Shaw.
Yes.
And you have not heard from Cheryl that Jim has a conflict on any of these people?
No, it's just an email that she sent advising that they were co-defendants. So if they qualify for counsel,
Okay,
find a new attorney.
okay. Mr. Young,
Yes, ma'am.
I have before me some serious drug charges where you have been charged on or about the 3rd day of October 2025 with possession of methamphetamine. But it's alleged that the weight in grams was more than 3.5, 15 grams, which qualifies it for a level 2 drug charge on the drug grid, which means that if you are convicted of a level 2, the sentencing range is 92 months up to 144 months, depending on your criminal history. And it is presumptive prison irrespective of your criminal history. So it's presumptive prison, but the length of time is dependent upon your criminal history, if any. But even if you don't have any criminal history, you're still presumptive prison. The paraphernalia is a low-level, level 5 drug charge, 10 months up to 42 months with the Department of Corrections, depending on your criminal history. Now, in counts 3 through 7, you have some misdemeanor and driving offenses. So I assume you were the driver of the vehicle that got stopped. It's also alleged that you had marijuana either on your person or in the vehicle somewhere that was apparent. So you're charged with possession of marijuana. That is a B, non-person misdemeanor in Kansas, 6 months, $1,000 fine, no mandatory minimums. Paraphernalia is also a B. They allege that they collected syringes, residue, spoons, glass smoking pipes with burnt residue, which is all considered paraphernalia. If convicted, that's a maximum 6 months in the county jail, $1,000 fine. You're charged with the first offense, driving while suspended. It's alleged that you operated a motor vehicle without a valid driver's license on the 3rd day of October 2025 in Butler County, Kansas. That is a maximum 6 months, $1,000 fine, mandatory minimum $100 fine, but no mandatory minimum jail time on a first, but there is on a second. Count 6, no proof of insurance. That's also a B. Non-person misdemeanor. Generally, it's a mandatory $300 fine, but it can be up to 6 months and $1,000 fine. Expired or registration that didn't match the vehicle or illegal registration. It is a unclassified misdemeanor, 30 days in the county jail, $500 fine, no mandatory minimums. I'm entering not guilty pleas for you on the entire case. And then I need to ascertain whether or not you're going to hire your own counsel. If you think you qualify for court-appointed counsel, I'll need some financial information. I'll also get some other personal information from you to determine what the bond should be set at. Your assigned judge is Judge Crum. Your court date with him is Monday, October the 27th at 2:30 in the afternoon. Sir, are you going to attempt to hire your own attorney, or do you want me to consider appointing counsel for you?
I need counsel, ma'am.
All right, how old are you, Mr. Young?
52.
52?
Yes.
What is your source of income?
Day worker.
What's a day worker?
I get paid by the day.
By who?
by whoever.
What's your legal source of income?
It is legal. You go there, they hire you. I don't know what you go there, they hire you. They're called day workers. We go and do whatever we're asked. Whoever picks us up, whoever hires us for the day, ma'am.
Okay, where do you go to do that?
It's in Wichita. Usually it's on Market Street. I don't know what you're asking.
Okay. Well, I mean, you got to have an employer. Somebody's got to pay taxes. Somebody's got to report your Social Security.
They pay by the day.
So they give you cash?
Yes, ma'am.
So you don't know who operates the whole thing?
You just go there and you stand, and if they say they want you, they take you. If they don't, they go.
Show us your tax returns.
Did you file any taxes last year?
No.
When's the last time that you did file some taxes?
Not last year, but the year before last.
Where do you live?
With my parents, 5454 Southwest Shumway.
In Augusta or El Dorado?
Dorado.
And how long have you lived there?
Probably 12 years, 15 years, right in there.
What's their names?
Karen and Jesse Young.
Okay. All right, well, I'll appoint Jim Watts to represent you. You have a court date, you have an attorney, recommendation on bond.
Judge, the defendant is a B on the grid. He is presumptive prison. He has a lot of criminal history, an arson, felony criminal damage to property, misdemeanor battery, misdemeanor theft. And a lot of that is from in the 80s and the 90s. The most recent stuff that I'm seeing is 2021 DUI, attempted aggravated burglary, domestic violence, 2007 felony flee and elude DUI, or felony DUI, I'm sorry, 2018 interlock. There's a registration offense as well. So he has a lot of criminal history. And as I said, he's a B, so we're asking for a $50,000 cash or surety bond.
Anything you want to say about your bond, sir?
Mr. Satterfield, I've been trying to do good. I really have. I mean, I haven't got any court dates. I haven't got any court commits like she said, in a long time. I'm asking you, please, Mr. Satterfield, lower that down to at least, 20,000, and I can bond out, and I'll show you I can do. I'm doing right. I don't really want to go into it because you'll tell me to be quiet, but I had nothing to do with the drugs, ma'am. I realized she asked me to drive her, and that's it. But I had nothing to do. I didn't know anything about the drugs.
Okay. Well, I entered not guilty plea for you. I'm gonna set your bond at 25,000 cash or surety. Do not violate the law. Show up when you're supposed to.
Yes, ma'am.
Unless you want to guarantee a one-way ticket to prison.
No, ma'am.
All right. Thank you. Oh, sir, will you?
Hey, 1 second, come back.
Sorry about that. Mr. Young, you're also not to have any contact with Janice Pickards that was in the car with you. She's a co-defendant. You're not supposed to have any contact with her as a condition of bond if you make bond too, okay?
Okay. My bond was 25,000,
Yes, sir.
should be 2,500.
It,
Yeah,
I'm not sure.
250,000. I'm not for sure what the 10% of that is.
Well, 10% of 25,000 is 2,500.
2,500.
Yes.
Is there any way that you could lower that, please?
No, no,
No.
no. Thank you.
Jim, do you have another one ready?
Judge, the other is at the jail, which is Jesse Young.
All right. You all have Jesse Young handy at the jail?
Yes, Your Honor. Mr. Watts, are you also representing Mr. McPherson?
I'm afraid so.
So, but Mr. Young?
All right, we'll go on the record in State of Kansas versus Jesse Lee Young Jr., case number 25 CR 455. Would counsel announce appearances, please?
Amber Norris for the state.
All right, James Watts on behalf of the defendant who appears in person from the jail.
This is the first setting on the preliminary hearing control docket. Announcements, Mr. Watts.
Your Honor, we'd ask this case be set for preliminary hearing, please.
Angela? Special setting date?
We can do the December 16th. You want to do it as a docket at 9 o'clock?
Can you do December 16th?
December 16, I can, Your Honor, assuming I'm not in trial.
Okay, well, let's set this for December 16th at 9. Does that give us 2 there now on that time? Angela?
Yes, Judge.
All right, December 16th at 9. Mr. Young, that'll be an in-person preliminary hearing here at the Judicial Center. All right, anything else on Mr. Young's case?
Yes, Your Honor, maybe we've heard on bond.
Sure.
Your Honor, it's my understanding Mr. Young's bond is currently $25,000. That is well beyond his have any ability to make. And the purpose of bond, of course, as we all well know, is not to do predisposition punishment, but to assure that a person shows up for court. That's frankly, the only real purpose for bond. There's other factors we consider.
Isn't community safety a factor as well?
What's a factor to be considered is where that bond is set, Your Honor, but is not the purpose of bond itself. Mr. Young is a lifelong resident, 20 plus years in Butler County. He has a residence in El Dorado. He's been there for 20 plus years. I will acknowledge he is a B on the grid, and should he be convicted, he's facing significant cases. However, he has agreed to do GPS as part of this. What we're asking for a $2,500 to $5,000 bond. I would note one of the factors that we consider on bond is the strength of the state's case. And I know this is not Amber's case. This is a case where there are 2 people in the car. My client, although he's driving the car, is not the owner of the car. The owner is present in the car. The bulk of the material that is found in the passenger's purse. The other items are found in a backpack, which is unidentified. And interestingly enough, the other person in the car is discovered standing on a baggie of methamphetamine as they get outside the car, dropped where she was apparently standing. There is very strong evidence as to the other person in the car. There is very little evidence that ties Mr. Young to this case other than his presence there in the car. Now, I will note that the other person in the car attempts to blame Mr. Young. Well, of course she does, because that would be her inclination. It's to save her own butt. But actual evidence is pretty slim as to Mr. Young. So we would ask that a bond be set in the $2,500 to $5,000 range.
Thank you, Mr. Watts. State's position, Ms. Norris.
Thank you, Your Honor. Your Honor, he is be on the grid, so he is presumptive prison, basically, no matter what the felony. So we did request 20,000 cash or surety at time of first appearance. Your Honor, the defendant was driving. The bag is in the console next to him. he's acting strangely and his story doesn't add up, are the notes that are made. Defendant's family ties actually did not appear to be in this area. They were in Emporia, you know, his local ties were in Emporia and Salina. And Your Honor, he has a long criminal history starting in 1984 as a juvenile, which started off with a bang as an arson. Lots of DV, yeah, lots of domestic violence, felony DUIs.
It started off with a bang as an arsonist? Was he cooking something? Like maybe something a little crystally? Wow. Another one with quite the criminal history. Let's see if Senate Bill 123 saves these guys.
No, he was driving the vehicle at the time of the stop, but has no driver's license, no legit driver's license based on all the traffic and the DUIs. Previous failure to appear in, let's see, 1998. Your Honor, it does appear based on the level of offense, based on the presumptive prison, based on information provided by law enforcement, that yeah, defendant is public safety risk and also presumptive prison. So, Your Honor, we would ask that the court maintain the bond as previously said.
Well, these are traffic and drug offenses. I'll set bond or modify bond to 7,500, cash or surety, GPS required. Defendant not to be in possession of drugs or illegal drugs or alcohol as a condition of bond. All right, anything else, Mr. Watts?
No, Your Honor, thank you.
Ms. Norris?
Your Honor, we would be requesting that the previous bond conditions had no contact with the co-defendant.
I'll
So-
maintain any prior bond conditions. Who's the co-defendant?
Ms. Pickert.
Okay.
No objection, Judge. We have no problem with that.
All right, and as also, if it's not a condition of bond, Mr. Young, you're not to leave the state of Kansas. All right, if there's nothing further, we'll be in recess. Mr. Young, you are excused. Thank you.
I'll go get those 2 no contacts, Your Honor.
Okay, all right, thank you. They're not no contacts with each other, though. Pickerts and Scott are not no contact with each other. They're no contact with somebody else. I don't know how they keep track of all that anyway. Pickert's assigned to Judge Ricky. Scott's assigned to me.
Judge, if they qualify for court-appointed counsel, I can always send the complaint out to another attorney and see if they can take it.
Do you want to start with somebody?
On Pickert,
Is Shannon Cooper doing felony appointments?
she is,
Let's just give them both to the Coopers.
to start with.
Yeah.
Okay.
I'm not sure why though, if they don't office the same place and they don't run them together, why Mr. Fabre can't take co-defendants. All right. Janice Pickerts.
Yes.
You've been charged in Butler County District Court case number 25 CR 457 with 1 count of possession of methamphetamine with the.
Who was expecting it to be Grandma? Show of hands? Anybody? The guy that we just watched is the co-defendant. This is the lady Watts was referring to about being the mastermind behind the whole thing. Yeah, okay. I guess it could be anybody, but I was not expecting it to be Grandma.
The intent to distribute a level 2 drug felony. It's alleged that on or about the 3rd day of October in Butler County, Kansas, you did unlawfully possess with the intent to distribute a controlled substance, to wit, methamphetamine. It's alleged that the weight of the drugs was 15 grams, which, because it's over 3.5, but less than 100 grams, is a level 2 drug felony. The sentencing range for a level 2 drug felony is 92 months up to 144 months with the Department of Corrections. There is no possibility for probation if you're convicted, or there's no presumptive probation category, I should say. Count 2, possession of paraphernalia, which were the baggies used to store the substance, is 10 months to 42 months with the Department of Corrections, up to $100,000 fine. The level 2 charge is up to a $500,000 fine. And then you're charged with a simple possession of methamphetamine, which is a lower level 5 drug felony, 10 months to 42 months with the Department of Corrections. And a misdemeanor paraphernalia, which involved the syringes and smoking pipes. That is a misdemeanor, maximum 6 months, $1,000 fine, no mandatory minimums. I'm entering not guilty pleas on all of these, especially since you have a high level felony. I'm entering a no contact order with Jesse Lee Young Jr. And I'm assigning a judge to you, Judge Ricky. And your court date with Judge Ricky is where did I place my sheet? Amy, what? Here it is. November 3rd at 2:30. I'm going to assign Shannon Cooper. Well, let me find out. See, you're like everybody else. Are you able to hire an attorney?
Living on Social Security widow benefits because my husband passed away in November.
Okay. So I'm going to appoint Shannon Cooper to represent you. Now, recommendation on bond.
Judge, Ms. Pickart's admits that the meth and that she's a meth user. It was her vehicle. She has no felony criminal history. The state would ask for $5,000 cash or surety.
Well, that's fairly generous for a level 2 drug charge, but I will set it at 5,000 cash or surety.
Thank you.
Okay. No contact with Mr. Young. Don't violate the law.
I won't go around him.
You're free to go, ma'am.
Thank you.
It's case number 2025 CR 457. Janice Pickarts appears from the court security Zoom location located at the Butler County Judicial Center. Brett Sweeney appears as prosecuting attorney, Shannon Cooper as defense counsel. This matter comes before the court at this time for a scheduled evidentiary hearing. What announcement is made regarding that at this time, Ms. Cooper?
Thank you, Your Honor. We've reached a plea agreement in this case. Ms. Pickards is prepared to waive preliminary hearing, and pursuant to our plea agreement, she plans to enter a guilty plea to count 3, and the state is prepared to dismiss the remaining counts.
Is that consistent with your understanding, Mr. Sweeney?
It is, Your Honor.
Ms. Pickards, importantly, you've been present when your attorney made the announcement that your case would be resolved at this point by you entering a plea of guilty and accepting conviction for possession of methamphetamine, a level 5 drug felony, as charged in count 3. Is that what your intention is here today?
Yes, Your Honor.
Ms. Pickards, it's court's understanding that you're waiving your right to a preliminary hearing and you're going to proceed with a plea hearing at this time. I do want to let you know that I've got a whole series of questions I need to ask you regarding the taking of a plea of guilty. If there's anything asked along the way that you do not fully understand, I will give you the opportunity to confer privately on this Zoom meeting with your attorney, Ms. Cooper, at any point.
Okay.
Just let the court know if you need that time to get some further private advice, okay?
Okay. Okay.
State your full legal name for the record.
Janice Elaine Pickards,
How old are you right now?
66.
What's the highest level of education that you've attained?
I graduated high school.
Do you believe you're going to have difficulty understanding the legal concepts we're going to be discussing in court here this morning?
I don't think so. I think I might be all right.
All right. Have you ever been adjudged to be mentally ill?
No, I've had depression before, but it's from like when I lose a family member. I'm not depressed now.
Are you supposed to be taking prescription medications at this time?
No,
Are you currently under the influence of alcohol or any drug?
no,
So as you participate today, Ms. Pickards, do you believe your mind is clear and that you do have a full understanding of what's going on here in court?
yes, sir.
Did you receive a copy of your original charges in the case?
Yes,
Do you understand the nature of the charge in count 3, possession of methamphetamine, a level 5 drug felony?
yes,
You understand that when you enter a plea of guilty, you are admitting that act that's been charged by the state.
yes,
Because you also understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that charge.
yes,
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you could present evidence on your own behalf at your trial and subpoena your own witnesses to court?
I didn't know that, but yeah, I can, yeah,
Okay.
thank
You
you.
also understand that you, at a trial, personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Okay, all right,
You understand that when you enter a plea of guilty, you give up all these valuable trial rights that the court has described.
yeah,
Are you also aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
yes,
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
yeah, it sounds bad, but yeah, I understand.
All right. You understand that you have a right to appeal a guilty verdict if you had a trial?
I can appeal it. Is that what you
If you
said?
had a trial, you could appeal if the case, if the verdict went against you.
Okay, yes,
You understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter a guilty plea. You understand that?
yes,
Now, are you aware of the possible penalties that could be imposed as a result of this guilty plea that you are attempting to make?
yes,
Okay, we're on the drug grid at level 5. In the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the worst criminal history category of A, you could receive up to a 42-month prison sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. Now, Ms. Pickerts, as you participate today, we do not know with absolute certainty what your criminal history is. You, better than anyone else here, should know what your own criminal record looks like. Without be researched by the Court Services Department, and based on the outcome of their research as of the date of sentencing, that determines where you fall along the level 5 drug line on the grid, and then you'll be sentenced accordingly. You understand that?
Yes.
Do you understand that if you have a person felony on your record at sentencing, you would be presumptive prison in this case? You understand that?
Oh, yes.
Okay. Did the concept of Senate Bill 123 get discussed with you?
Judge, I don't think I called it that. I did talk with her about the possibility of treatment and evaluation getting ready for sentencing, and that she'd likely be eligible based on what we know of her criminal history.
All right. Ms. Pickard, Senate Bill 123 is a commonly used term that we have here in the judicial system that refers to a law which essentially requires mandatory substance abuse treatment for certain offenders. You may or may not qualify for that program. If you do qualify for it, do you understand that you could be required to participate in substance abuse treatment for up to 18 months?
Yes.
All right. Do you also understand that you could receive up to a $100,000 fine for this offense?
Oh my. I didn't know, but yes, I guess.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
You also understand as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, and or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Okay.
You also understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Okay. Yes.
You also understand, Ms. Pickert, that the Kansas Sentencing Guidelines Act is much more than just the grid that I referred to earlier. It's an entire book of sentencing rules and laws. Do you understand that if any special rules apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
Yes.
Did you have an ample opportunity to fully discuss legal matters like this with your attorney, Ms. Cooper, before proceeding here today?
Yeah, we talked a little bit.
Well, a little bit worries me. Do you want any more time with her privately now before we go further? Ms. Pickards?
Yes.
All right.
Yeah.
We're going to pause briefly.
Okay.
We're going to put Ms. Cooper and the defendant, Ms. Pickards, into a breakout session, and you can ask whatever questions that you still have at this time, Ms. Pickards.
Okay.
We'll recess while that's taking place. Following a brief pause in the proceedings, I think we're ready to reconvene here. My understanding that we're still recording and broadcasting, Mandy?
Yes, Judge.
Very well. Ms. Pickert, you've now had the opportunity to confer privately with Ms. Cooper. Are you ready now to go forward even further with this plea hearing that we're conducting?
Yes, sir.
Right. Are you satisfied with the advice and services that have been provided by your lawyer, Ms. Cooper?
Yes.
Now, Ms. Pickert, this guilty plea that you're attempting to make hasn't been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
Okay.
Okay.
He's asking you a question.
I asked a question, but I didn't receive a response. Are you doing this plea because you've been threatened to do so?
Oh, no, no.
Have you done this plea because you've been promised something?
No.
Okay. You understand, Ms. Pickert, that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, But this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
I understand.
All right. So let me ask you, how do you formally plead to the charge in count 3? Possession of methamphetamine, a level 5 drug felony.
Yes,
Yes. What's your plea?
guilty.
Very well. According to the state's charging document, Ms. Pickers, this took place on or about October 3 of 2025. Is that when it happened?
Yes,
It happened somewhere in Butler County, Kansas. Where was it?
just right outside El Dorado, past the Bromgars.
Okay.
The,
And it's alleged that you possessed the controlled substance methamphetamine on that date. Did you?
yes,
Where was it?
and it was in my purse.
Okay. And you knew it was there?
Yeah,
And you knew it was methamphetamine?
yeah, pretty much, I guess.
What do you mean pretty much?
Well, I knew it was, I knew, yeah.
Okay. Do you have the right to legally possess methamphetamine in the state of Kansas?
No,
So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for the level 5 drug felony of possession of methamphetamine?
yes, I do.
All right. Mr. Sweeney, do you know of any legal reason why the court shouldn't accept this defendant's plea?
No, Your Honor.
Ms. Cooper, are you aware of any such legal reason?
No, Your Honor.
Ms. Pickards, are you aware of a legal reason or any other good reason why the court
No.
shouldn't accept your plea here today?
No, I'm hoping you do.
Court accepts the guilty plea made by the defendant and finds that that plea is made voluntarily. She has an understanding of the nature of the charge against her and the consequences of the plea, and a factual basis for the plea does exist. The court finds the defendant guilty and adjudges her therefore convicted in count 3 of the information of possession of methamphetamine, a level 5 drug felony. All other charges of that charging document are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Ms. Pickard's criminal history, and the court will set an appropriate date for sentencing. Ms. Pickards,
Yes,
I'm going to leave you on your bond, even though you've now been convicted of a felony. However, additional conditions of your existing bond will now include full cooperation with the pre-sentence investigation process. You very well may be asked to do one or more assessments, one being a risk needs assessment. The other may be a substance abuse assessment of some kind. They're separate and distinct. You'll need to make sure that you contact court services immediately
okay,
after this hearing. And in fact, you're in the building. So court security can direct you to the court services department if you don't know where it is. Check
okay,
in with them and then follow their direction about what you need to do as part of this pre-sentence investigation and setting up these assessments. Ms.
okay,
Pickers, even though I seem to give this speech in every case, a lot of defendants don't seem to get it, that they're responsible for making sure that their assessments get scheduled and properly completed in time that we can do our sentencing about 60 days from now. If they
okay,
don't get done, and I find you at fault, I will hold you accountable.
okay,
Okay? So let's go ahead and set our date, Ms. Pickards.
all right,
We're actually going to be in 2026 for that date. Mandy, I'm going to have you suggest a date in mid to late February that we might have available for Ms. Pickards. Is there any time, Ms. Cooper, that we need to particularly stay away from?
Monday, the 23rd, I have an all-day hearing scheduled. So it just sort of depends. I think there's several openings mid to late February other than that.
Okay. Mandy, what do you suggest?
I suggest possibly February 12th at 9 a.m.
February 12th, 9 o'clock a.m., counsel?
Works for the state, Your Honor.
I can't do 9 a.m. that day. I could do later in the afternoon if possible.
We have something scheduled in the afternoon.
Okay.
Okay. The afternoon of February 10th. Would that be too soon?
No,
Okay.
I have a very short hearing at 1:30 and I'm available the rest of the afternoon that day.
You want to do 3 p.m.?
Okay.
Okay.
all right. The court will set February 10, 3:00 p.m. for the sentencing date and time in this case. Court contemplates it'll be conducted by Zoom. Ms. Pickards, there's only one place that you can appear, and that is at the court security location at the Judicial Center, just like you did today.
Okay.
Okay, that's where you have to participate from for your sentencing.
If I were a defendant facing sentencing, that statement right there would scare the hell out of me. I'd be like, why there, Judge? Am I getting arrested? I can go to my lawyer's office? What do you mean? What do you mean it has to be in court security? How many days are you going to give me? Like, you have to tell me now. I would be like one of them people on a body cam video. No, you can't take me in. You can't take me in.
Okay.
February 10, 3:00. Make sure you check in a little bit early so that they can get you in to the proper location to participate in that sentencing proceeding.
All right.
And again, Ms. Pickard, you'll need to go right to court services after court, check in with them, follow that office's direction about what you need to do to be successful on this pre-sentence investigation process.
Okay.
Okay.
I'll go right there.
Okay. Before you do, Mr. Sweeney, is there anything else we need to address regarding Ms. Pickards at this time?
No, Your Honor.
Ms. Cooper, anything further at this time?
No, Your Honor, thank you.
Any questions for the court at this juncture, Ms. Pickards?
No, I understand.
Do you, Miss Pickard? Let me prepare you.
Anything else comes up, just contact Ms. Cooper. She can answer your questions.
Okay.
All right. If there's nothing further, then the Janice Pickards matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you.
Thank you.
It's case number 2025 CR 457. Brett Sweeney appears for the Office of the Butler County Attorney in the state of Kansas. Shannon Cooper is defense counsel. Janice Pickards appears from a court security monitored location at the Butler County Judicial Center, all by Zoom. This matter comes before the court at this time for sentencing. The court's docket notes indicate that the defendant appeared before this court on December 18 of 2025. At that time, she entered a plea of guilty to count 3, possession of methamphetamine, a level 5 drug felony. A pre-sentence report was ordered with sentencing set for today. Court has received a completed pre-sentence investigation report compiled by Christine Donovan, pre-sentence investigator who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No objection from the state, Your Honor.
And I trust that the defense has no objection, Ms. Cooper?
No objection, Your Honor.
Very well. The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentencing should not be pronounced in this case here this afternoon?
I know of none, Your Honor.
Ms. Cooper, are you aware of any such legal reason?
No, Your Honor.
Ms. Pickards, do you know of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing here today?
No, Your Honor. Sorry, my voice. I was losing my voice. Sorry. I said no, Your Honor.
All right. The court has reviewed the file. I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion for this court to take up. Does the state have any such motions to pursue, Mr. Sweeney?
No, Your Honor.
Does the defense, Ms. Cooper?
No, Your Honor.
Very well. Are there any victims or members of a victim's family present who desires to address the court in relation to the Pickard sentencing? The court finds no such persons present, so at this time, the court will ask for recommendations from counsel regarding an appropriate sentence, beginning with Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, pursuant to plea agreement, the state is recommending the standard and mid-box 11 months in Department of Corrections. As well, we would recommend the corresponding maximum good time percentage and probation supervision release duration periods. Ms. Pickett's does have 3 days of jail time credit. Given how she scored on the pre-sentencing evaluations and a low Warner score, she's not mandatory Senate bill eligible, and she qualified for 12 months of court services probation, and the state would recommend the same. We would ask for the adoption of all of the conditions that are listed within the PSI. They all appear to be appropriate. I guess specifically also the drug and alcohol evaluation and follow the recommendations contained within that. I would also note specifically the no contact with the co-defendant, who is Jesse Young Jr. As far as costs and fees, in this case, Your Honor, the state is not requesting a fine.
I don't know if she would want to contact Mr. Jesse Young Jr. He did throw her under the bus and blame it all on her. Well, his attorney did, but he seconded that motion.
We are requesting the court costs. There was a KBI laboratory report that was completed, and I'm not sure how the court wants to deal with this, but because there was a co-defendant's case, Ms. Pickett's pled before the KBI laboratory report was returned to our office, but we had to leave those reports out for the co-defendant's case. So it's completed now, but it wasn't at the time she pled. We would ask for a DNA fee. This is a first-time felony. We would ask for court services supervision fees and any other standard fees. And then, of course, would ask the courts to take a look at attorneys and bids fees as well.
Thank you, Mr. Sweeney. Ms. Cooper, what are your recommendations regarding an appropriate sentence?
Thank you, Your Honor. I think the recommendations outlined in the PSI as well as have been recited by Mr. Sweeney are appropriate. I'm asking the court to follow those recommendations too.
Very well. At this time, the court will address the defendant, Janice Pickett's, personally, and the court will ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court.
No, Your Honor.
Ms. Pickert, it's the court's duty to look over the pre-sentence report, including defendant's version of the crime. I'm disappointed in your response. You write in response to how the offense was committed through the acts of other people. That's a great attitude, Ms. Pickert. You're not taking responsibility for your involvement in possession of methamphetamine. Is this suggesting to me that you're trying to divert the responsibility to someone else?
No. No, sir.
So why the reference to acts of other people? Aren't we here to judge your actions?
Yes. I'm willing to do whatever it takes to. I was in the wrong. I'll take the punishment I get.
Anything else, Ms. Pickert?
That's it.
No, I'm sorry, I didn't hear that response.
Yes, sir.
The wheels are turning in Judge Ricky's head. She apparently really didn't understand that. I love his confused look. But he is less than charmed right now.
Okay, you don't have anything else to present to the court?
No.
Okay.
No, Your Honor.
Court will pronounce sentence in the case at this time. Court hereby establishes count 3 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of I, thus placing her in grid box 5 drug I. The court hereby sentences the defendant to a term of 11 months in the custody of the Secretary of Corrections of the state of Kansas On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Court does find that in grid box 5, drug I, this is a presumptive probation matter under Kansas law. The court will follow the statutory presumption of probation and order the defendant into probation supervised by the Court Services Department for a period of 12 months initially. Conditions of that probation will be this defendant observing all laws, reporting to an officer as directed, to obtain an approved substance abuse evaluation within 45 days of today's date and abide by the recommendations of that evaluation. The defendant shall not possess or consume alcohol or illegal drugs. At her supervising officer's request and at her own expense, she shall submit to random breath, blood, and urinalysis testing, gain and maintain employment suitably throughout her probationary term, notify her supervising officer within 24 hours of any changes in employment status, residence, telephone number, or email address. She shall have no contact with co-defendant, which I think was identified as Jesse Young Jr.
Yes,
Okay.
Your Honor.
The defendant shall submit her DNA to the KBI databank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by her probation officer, follow all recommendations of the drug and alcohol evaluation, and complete all recommended treatment and aftercare, follow all standard conditions of probation, not have in her possession firearms or dangerous weapons, and avoid disreputable characters or places. In other words, anywhere where you might get exposed to illegal drug, Ms. Pickards.
Okay.
Anywhere you would go where drugs are is a disreputable place. Anybody who does drugs or possesses drugs is a disreputable character. Pretty simple.
Okay. All right.
Shall I also make monthly payments on your obligations? Your obligations will include a felony docket fee, felony probation fee, $200 DNA fee, $100 bids application fee, and the court will also assess $387 in legal fees and waive any remainder. I trust, Ms. Cooper, your fees will exceed that amount.
Yes, I think they will, Your Honor.
Looking at the financial information in the pre-sentence report, Ms. Pickards, it does appear that you have bills less than your monthly household income of $1,774 a month. Paid out over time, you should be able to afford the $1,000 total, which the court has ordered. Implicit in this court's order is that it is not assessing a KBI lab fee under the unique circumstances of this case. You will be required to pay at least $83 a month on these obligations, starting with the calendar month of March of 2026 and all subsequent months until the case is paid in full. Ms. Pickards, I highly recommend that if you can pay more aggressively, that you do so, because the court's not going to approve you being released from probation until you get this case paid off.
Okay.
Especially with the rather disturbing response on the pre-sentence report, Ms. Pickards, this court has considered an assessment of jail time as a condition of probation. I'm sure that you've been advised that the court has the authority to order up to 60 days in the county jail as a condition of probation. The court has considered that here, but I think you only saved yourself, Ms. Pickards, by what you stated to the court today, that you do take personal responsibility for what you did and you do appear to be sorry for it. So I don't know what you meant by your comment in the pre-sentence report, because quite frankly, you didn't explain it. But I do think that you do show that you are amenable to probation, that you do recognize that you committed a wrong and you want to make it right.
Yes. Yes, Your Honor, I do.
The court will grant the defendant 3 days of credit for previous jail time served, but will grant an outright probation at this time. Before I get any further, Ms. Donovan is here from Court Services. Ms. Donovan, what direction would you give Ms. Pickards today as she's at the Judicial Center?
Your Honor, she needs to report to the Court Services office when she is done here today.
All right. The court so orders. Ms. Pickards, when you're done, you need to report to the Court Services office. Do you know where it is at the Judicial Center?
I think so. I think I talked to her one day down there.
Okay, well, court security can give you direction. If you need any help in finding that office, you need to report in person to that office today before you leave the building.
Okay, I will, Your Honor.
I've got some other matters I need to address with you. Ms. Pickard, you may have the right at some point in the future to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain circumstances, a criminal defendant in Kansas has the right to appeal a conviction to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and to make sure that they're supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. And you do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. Ms. Pickard, I'll remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Mr. Sweeney, I'm looking at my notes from this proceeding. Are you aware of any other sentencing-related matter which the court has not yet fully addressed?
No, Your Honor, thank you.
Ms. Cooper, are you aware of anything further at this time?
No, Your Honor. Thank you.
I want to make sure the record reflects that any bids amounts that bids pays for Ms. Cooper's services in this case in excess of the $387, which I assessed today, along with the $100 bids application fee, would be waived. That excess would be waived. Ms. Pickard, do you have any questions about the court sentencing orders?
No, sir.
Okay, do you know where you need to go after court?
Yes.
The Butler County Court Services Office, okay?
Yes, sir.
Report in with them and then follow their direction regarding future reporting, all right?
Okay.
All right. If there's nothing further at this time, then the Janice E. Pickard sentencing matter is concluded. The court is in recess.
And this meeting may be ended for all. Hi. I'm struggling. I'm struggling something mighty fierce here. So, yeah. She dealt deadly drugs. Of course she's going to jail. Yeah, everything's just a word. Easy to change. Oh, guess what, guys? I'm going to be working on this. I don't know. I didn't have any more hearings. Those were the only 2 hearings with him that I could find. I'm sorry. A shit ton. A metric shit ton. Not a standard shit ton. A metric shit ton. Oh, he didn't send her to jail? I kind of wasn't listening. I'm sorry. Oh, you rolling your eyes at me? Are you rolling your eyes at me? Well, I'm seriously riding the struggle bus on this one board right here. I can't get it to go into the crevice because it's got all of the places for the board cut out, and then you just slides into it, and then there's holes pre-drilled for the screws, sort of. They're a little wonky on some of them, but my impact wrench doesn't strip the screw, thank God. Yeah, I'm gonna be playing with this for a bit. Basically, It's a wheel for cats, an exercise wheel. Don't you roll your eyes at me. Quit it. I love you. All right, guys. Be safe, be well, sleep sweet, and much love.